Hi everyone, welcome to the last of our webinar series and our educational series. So lovely to see everyone here. Just a few housekeeping matters before I get started. If there are multiple people watching on one computer, we would really appreciate if you're able just to type your individual names into the chat box function. That just helps us keep track of the total number of people participating in the webinar. Also, at the end of the webinar, we'll be sending out a survey through SurveyMonkey, and we'd really appreciate if you're able to give us some feedback on how useful you found the webinar or what else could have been included. Just any other issues, if you've got any questions during the webinar, please feel free to use the chat box function and I'll do my best to answer them. And obviously I'll leave the chat box function open at the end of the webinar as well, just for any people that have got any questions at the end of the webinar, and you can feel free to contact us after that as well. Those who have watched our earlier webinars will know that this is a series dedicated to sort of in-depth issues in education law, and this is our final one today, just talking about privacy and other issues in schools, such as the right of students to their own information and how they can be dealt with relevant school staff, such as school nurses or otherwise, or school counsellors. So I'm just going to get started now. If there are any issues with sound or vision, please feel free to send Velda a message through the chat box function. She's fantastic at assisting with all the tech side of things. And we will make the slides available after the webinar for those that want to view them, and also we'll eventually get them up onto our YouTube channel for those who want to re-watch the webinars at a later date. So we'll just get started now. So I just wanted to give a quick overview around the right to privacy and just the right of children to access their information in general. So international law informs all of our domestic law. So those who tuned into our earlier webinars, remember I talked about the fact that we're in a dual-list system in New Zealand. We have our domestic law, which is enacted by Parliament. In this case, for instance, we're talking about the Education Act, which gives a right to education, but all our domestic law is still influenced by international law and international conventions which New Zealand has ratified. These international conventions aren't automatically incorporated into New Zealand domestic law, so that's why we call our system a dual-list system. It's not a monist or single system that other countries might have. So, for instance, New Zealand has ratified the Universal Declaration of Human Rights, one of the first human rights treaties formulated after the aftermath of World War to sort of set out the rights of all humans. Although that hasn't been specifically incorporated into our domestic law, so there's no Universal Declaration of Human Rights Act, New Zealand 1948 or whatever it is, it still is a really important part of our law, so it informs how we interpret all other domestic pieces of law in our country. So obviously the government wouldn't be able to enact any law that was inconsistent with the Universal Declaration of Human Rights. So essentially, when we're looking at domestic law and how we interpret it, and I'm thinking in particular with this webinar, for instance, the Privacy Act, it would be interpreted in the context of the international conventions and also international commentary which the United Nations committees may have issued in respect of how these rights can be implemented. Also quite important is the International Covenant on Civil and Political Rights, otherwise known as the ICCPR, very important international treaty. It really establishes the basic rights to civil and political freedom. So all those things that we sort of expect and take for granted, such as the right to vote, the freedom to associate with people, the right to freedom of movement, things like that, all contained in those international treaties, and also to an extent also incorporated into our domestic law, for example, under the Bill of Rights Act 1990, which exists in New Zealand. Both of these international treaties set out a basic right to privacy for all persons. So it's a basic human right that you're entitled to privacy in your life. And obviously, if you have information that is personal to yourself, it's only up to you to determine when you share that information with another person or another agency or the wider public. Also important in the context when we're talking about young children is the United Nations Convention on the Rights of the Child, otherwise known as UNCROC. Those who've tuned into our earlier webinars will remember I talked about UNCROC, and I talked about it in the context of the right to education and the right to of young people to have a voice, but also there's an understanding within the convention that young people have the right to privacy of their own matters as well. So this becomes quite relevant when we're talking about whether or not, for instance, a staff member at school is sharing private information about a young person with an external agency or otherwise. So under the UNCROC articles, it's set out that children are entitled to dignity and respect. They are seen as autonomous individuals. So the convention really comes from a rights-based perspective. Children are autonomous individuals that have rights in and of themselves. They are not seen just as an attachment of their parents or parents' property, but they are entitled to their own fundamental human rights in and of themselves. Within the convention, there is an understanding of children's rights to privacy as individuals with rights. So I've just cited there an example in domestic law which reflects this international law. So you'll remember I talked about the fact that the convention hasn't been specifically incorporated into New Zealand domestic law, so there is no United Nations Convention on the Rights of the Child Act, New Zealand, but our domestic law will be interpreted consistently with those international obligations. So, for example, provided for in our domestic law, Section 38 of the Care of Children Act 2004 sets out a female of any age can consent to an abortion. So that is really affirming the belief that children are entitled to dignity and respect. They are autonomous individuals in their own rights, and they have the right to make these decisions. One of the things that you might hear tossed around occasionally when people are discussing autonomy of children and the right to make a decision is sort of the Gillick principle. You might hear that tossed around here and there. It's reference to a particular case, the idea being that we respect young people when they're cognizant and able to form their own views on matters to make those decisions as autonomous beings. So just a bit of a general overview about guardianship. I talked a little bit about this in our first webinar, but it's just going to become relevant to when we talk a little bit later in the webinar about the right to privacy and parents' rights to information over children and how they can access that information if someone else besides the young person holds information and they want to access it. So guardianship endures until the age of 18. So guardians are, sort of default mum and dad, birth mum and birth dad, and they're given the rights as guardians in terms of access to information and major decisions to a certain point, which we'll talk about a little bit later in the webinar. So, for instance, if there's an issue about whether a young person receives a blood transfusion, they've been in a car accident or something like that, guardianship would sort of say, well, they might have a say in the major decisions of that young person's life. Care of Children Act 2004 is the relevant domestic law to refer to in that case. Young people can, at the age of 16, choose to leave home, so they're deemed to be, in a sense, mature enough to make that decision. But guardianship might still be in place until the age of 18, but a young person might leave home at the age of 16 because they're deemed to have sufficient maturity and decision-making capacity at that stage. Obviously, there is a sort of a crossover here with child, youth and family in the sense that their jurisdiction finishes at age 17. So so I've just seen a comment pop up in the comment box. Brendan, thank you. Religious instruction and overseas travel too. That's right, yeah. So under the Education Act, there are provisions which deal with when a parent can seek for a particular child to be exempted or included in particular parts of the curriculum. And yes, overseas travel. At the age of 16, however, the young person can make a choice to leave home and their passport would become their property and they're entitled to take that with them when they leave home. So we quite often get queries about that from young people. Yes, and absolutely right. The guardianship can extend up to age 20. However, generally, care of SIS would only extend to the age of 17. So essentially, once children are in care and they're 17, although there is a lot of talk in the media about changes to this, but there is talk about extending that age up. But once they reach, children in care reach the age of 17, then they essentially are deemed adults and sent out into the world. So I think, a lot of the stuff in the media is talking about the fact that a lot of young people aren't well equipped for that transition into the world once they leave care at the age of 17, particularly when usually you have to be 18 to sign a tenancy agreement and do lots of things like that, which can make it quite difficult. The important point that I really just wanted to make, without getting into too much detail of all of this, is that a guardian is not necessarily entitled to all the information that is held about a young person. So just because they're a guardian and just because you might be a default guardian, your mum or dad, or you've been appointed a guardian by the family court, for instance, if mum and dad aren't in the picture and grandma's been appointed a guardian, it doesn't mean that grandma or whoever it is, a guardian, has the right to automatically have all the information about that young person. So you'll remember one of the slides back, I talk about a young woman being able to consent to abortion. If she makes that decision and that is her own autonomous decision to seek medical treatment, and that information is confidentially exchanged between her and a doctor, it doesn't necessarily mean that her guardian's got the right to access all that information just because they're a guardian. So just really, without getting into the ins and outs too much around the law, the key point is that guardians, whether appointed by the court or just default by virtue of birth certificates or otherwise, they don't have the right to automatically access all information about that young person. So I wanted to talk a little bit about the concept of loco parentis. So there's this old sort of common law concept or common law understanding historically that's arisen, which sort of states that schools, whilst they're looking after these students during the day, during the schooling day, they're sort of like in the position of parents. So that's the idea of loco parentis, in the position of being like a parent whilst child is in care at school. It's quite an old concept, quite a historical concept. It's sort of gone through a bit of evolution over time because obviously there's more prescriptive detail from the Ministry of Education in respect of what is expected of schools in providing a healthy and safe environment, or school rules and things like that. It's sort of not quite in the sense that you'd expect, for instance, a teacher to step in and make a decision that a parent might make about a child, but it's sort of the idea that there is, to some degree, some jurisdiction of school staff over children to an extent, obviously not completely to the extent that you would expect parents to have jurisdiction over a student, but to an extent over that student in terms of things that might occur at school and potential things that might affect their life. I'll probably say that the concept now, the common law concept, is probably a lot more relevant in the context of things like students that are boarding. So for instance, education hostels. So there's education hostels regulations 2005, a piece of domestic law regulation. And common law is to a large extent now limited by the domestic law we have. So, for instance, corporal punishment is outlawed now, and perhaps if we all know about the smacking laws and the argument that parents be able to use reasonable force to discipline children, but that would not be permitted in a school environment on the basis that a school staff member was loco parentis. So it is kind of a older, slightly outdated concept, and a lot of the stuff that governs how schools carry on their relationships with children is probably more governed by law rather than common law now. But it is an important concept nevertheless, because it does influence to an extent the fact that schools are in this position and they do obtain and have relevant information about students at times that they hold. So what about privacy and a student's right to privacy in school? there is no clear legal definition of privacy. Obviously, we have domestic law like the Privacy Act and things like that, and we have international treaties which talk about a right to privacy, but it's not as if we can refer to a specific page-long document which details exactly what type of privacy is provided for, what happens when that is breached or anything like that. It's quite dependent on the circumstances, and it's a bit more broad and interpreted in the context of domestic law and international law. So the right to privacy refers to a right of an individual to restrict or prevent release of personal information into the public domain. So I've drawn very largely from case law under the Privacy Act in respect of that when I give you that sort of vague general statement. And the key thing about the Privacy Act, which is protecting at a domestic level, and commentary around the international treaties, is that the right to privacy protects the freedom of an individual to choose for themselves if information is to be shared, and that's a fundamental human right. So, as I said, domestic law is the Privacy Act 1993. You'll see that it's quite detailed in terms of just various provisions for people requesting private information, dealing with requests for private information, and the Act also sets out information privacy principles. So, for instance, Privacy Principle 11 deals with the obligation of employers to hold confidential information of employees and things like that. So, a lot of sort of vague more general principles are encapsulated in those principles, which can be referred to provide a bit of guidance. I just wanted to flag the fact that privacy is different from confidentiality. So confidentiality is more of a legal concept which deals with a relationship of trust between two people. For instance, I know that under the Law Society Code of Conduct for Lawyers, confidentiality has a specific legal meaning which deals with the confidential relationship that is exchanged between a lawyer and their client, and the obligation of a lawyer to keep that information confidential to them for the purposes of giving legal advice. So under the privacy principles, it is set out that personal information is not to be collected except where it's necessary for a function or activity. Personal information can be obtained from a person concerned. So if I have private information about my medical history and I'm quite happy to share it with someone or another agency, that's my choice, and I can freely give out that information because it's my information to give out. The principles also set out that an agency that holds personal information must ensure that the information is protected by reasonable security. So obviously read into that context dependent of what is reasonable and how they best protect that. But it's essentially, for instance, with casework we have to ensure that not only we're compliant with Law Society obligations to keep clients' information confidential, but also as an agency holding that information, privacy should be protected, and we should have reasonable measures to ensure that. An individual about whom information is held is entitled to request and have access to that information. So anyone that holds any information about me, I should be able to access that information. So if my doctor holds all my medical records for the past 10 years and then I need to make an insurance claim, I'm entitled to contact the doctor and seek records for the past 10 years which they hold, because that is my information and they hold it and it's mine, so I should be able to access it. There are sort of a few tricky bits here and there when you come into the employment law context. So sometimes there are exceptions, and the situations we come across in the employment context usually have to deal with evaluative material and confidential evaluative material that might have been prepared for a prospective employee and an employer considering this prospective employee. At times there may be things generated which are for the purposes of evaluation or generated on a confidential basis for an opinion on a particular person. There are very limited circumstances in which that exception might apply, but I just kind of flag it there as just in case there's ever a situation where you're supporting a young person and they are in that situation. It's highly unlikely that it's easy to get within that exception though, so it's worth challenging definitely if you are supporting a young person in that case. The privacy principles also set out that reasonable steps should be taken to check that information is correct before it is used, and also that information should not be held longer than is necessary. So obviously, if there is particularly private information that someone else holds, you would expect that they would only hold it for the requisite period that is necessary, and then they would not hold it beyond that time. Obviously, that's to protect the person and their own privacy as well. A key thing to remember and bear in mind under the principles is that information can only be used for the purpose for which it's collected. So if it's only collected for the purpose of, for instance, assessing, say that I go and get an x-ray done on my wrist to see if it's sprained, that is the only purpose for which the doctor can use the information. The doctor can't then forward it on to the insurance company for the purposes of assessing whether or not they would want to decline the particular claim, because I would have to authorise release of that information, and that information had not been collected for that purpose in the first instance. So personal information should not be disclosed to anyone other than a person unless they are authorised to receive that information. So you probably would have seen the disclaimer that goes around on lots of emails to people, which is, if this information has been received mistakenly, please ensure that it's deleted and returned to the sender. So that's again that sort of protection of privacy in some cases. So where do teachers factor into all of this? I mean, they're not exactly loco parentis, they're not exactly, in the case of parents, but they still have certain obligations that flow from being teachers at school, and they might pick up or receive potentially very private information about a student in their class. So teachers do have some obligations of privacy or confidentiality. The Code of Ethics for Registered Teachers notes that teachers will strive to protect the confidentiality of information about learners obtained in the course of professional service consistent with legal requirements. Now, that's a big mouthful, but essentially, the Code of Ethics seems to give guidance that teachers should strive to protect this confidential information they might obtain in the course of teaching. Health information, what do you do if you're dealing with a student where you receive a disclosure or information which is probably quite personal in terms of the student's own health? The Privacy Act Code states that in respect of a disclosure of information regarding health, that New Zealand educators are bound by the Health Information Privacy Code 1994. So this can be particularly difficult, for instance, if you're dealing with a young student and you become aware that she's consuming birth control, seeking birth control, or maybe pregnant. Obviously, parents in that situation might have a legitimate interest in knowing this information, but some of the obligations around ensuring that private information, you strive to retain private information, can essentially bind a teacher from making a disclosure off the bat, just like that. So, Privacy Code Rule 1, proper purpose. Health information not to be collected by any health agency unless the information is collected with a function or activity of the health agency or collection of information is necessary for that purpose. So I've covered that already. Essentially, if you wanted to have a look at it in more depth, feel free to have a look at the Privacy Code, definitely easily accessible via a Google search. Rule 2, the source of information. Where health information is collected, the health agency must collect the information directly from the individual concerned unless the agency believes on reasonable grounds that compliance is not necessary. So, I mean, they'd have to have reasonable grounds to do so, and I think it would be quite a hard sell just to assert that they don't think on reasonable grounds that compliance is not necessary. There'd have to be some objective extraneous evidence which supported their assessment that that was appropriate in the circumstances, probably a relatively high threshold as well. So, I mean, there may be, particular cases or interpretation by the Commissioner about these particular points, but I won't go into the specifics of it, but it's probably possible to find out some precedents in terms of when that's occurred. So the Privacy Code sets out that compliance is not necessary where the individual concerned authorises collection. So really easy, like if I say, sure, grab a copy of my file from my doctor, then I've already authorised collection. Where the individual is unable to give his or her authority and the information is collected from an individual's representative. So obviously an authorised representative, an authorised agent. For instance, one clear example would be a power of attorney. But yeah, someone else might be authorised as a legitimate agent to access that information. Where compliance would not prejudice the individual concerned, probably quite limited circumstances in that case, but certainly if they were able to show that. If the information is already publicly available, so if someone's already publicised it on a public website, it's not necessarily private information anymore. Or if the information is used in a form where the individual concerned is not going to be used in a form where the individual will be identified. So if it's an anonymous story or an anonymous report where there are no identifying particulars of that person, so no one will be able to find out that it was that person. Rule 11 limits disclosure of health information and sets out that a health agency that holds information must not disclose the information unless the agency believes on reasonable grounds the disclosure is to the individual concerned or the individual's representative where the individual is dead or unable to exercise his or her rights. So, quite strong protections around that, the idea being that health information should be private to you and you shouldn't face that information being disseminated to the public unless you consent to it. School nurses, they often receive really sensitive information. So when it comes to things like contraception, abortion, sexual activity, activities of the young people, school counsellors and nurses would need to ensure they obtain consent of the individual before they share information with a parent or school staff or management. So, the school nurse can't just become aware that the students have done something which potentially gives rise to discipline within the school. Say that two students have gone into a particular room in the school and had sex or something like that. Potentially that could be considered gross misconduct under Section 14 of the Education Act. Could give rise to discipline. However, the school nurse does have obligations not to simply disclose sensitive information that she comes into receipt of. Him or her, actually, I should say. So it is important to bear those things in mind because the young person does have a right to privacy. So going back to the things I talked about earlier, such as the international treaties and also the Privacy Act and the UNCROC in particular, and the right of a young person as an autonomous individual to privacy. So the Auckland School Nurses Group has released a best practice guide outlining how to deal with privacy and confidentiality of students. Able to be found online. We were able to access it through a quick Google search the last time we checked, although we did draft the webinars a little while ago, so I stand to be corrected if you do a Google search and it doesn't come up immediately, but hopefully it should be easily accessible. So the guidelines note that students should be made aware of their right to confidentiality, and there's 4 exceptions that are set out there. If they intend to harm themselves, if they intend to harm someone else, if they're being harmed by someone else, or they know someone who may intend to harm themselves or someone else. So that's sort of that thing about risk of imminent harm, and if the school nurse needs to act to prevent that risk of imminent harm. I think the real test will be whether or not it's imminent and the harm is genuine and tangible. Students are to be made aware that if they disclose any information with the 4 harms, that assistance will be facilitated. Students are encouraged to talk to their parents or caregivers about concerns or allow with permission the nurse to do so on their behalf. So again, the nurse has to be authorised to do so. And again, because remember, you'll recall that I talked about the fact that children can leave home from the age of 16. From age 16, they should have full control over their health information as well. School counsellors also have guidelines. So obviously school counsellors probably come into contact with lots of different student issues, and there is quite a lot of disclosure of quite sensitive and quite private information at times. So there's a school guidance counsellor kit online, and it sort of gives some, guidance around how to deal with all of this. A counsellor does not breach privacy if they received unsolicited information. So if it's just suddenly become aware of something that has not been solicited, it does not necessarily result in a breach of privacy. But note that the guidelines set out that if a counsellor solicits information about a client, for instance from another counsellor, it's important to obtain consent of that student. Information can be obtained from other sources if it is not practicable it would prejudice the client's interest or safety. So again, you're needing to prove a risk or some sort of harm is going to occur if this doesn't happen. Under the Privacy Act, privacy can be breached where an unauthorised disclosure can be made to prevent or lessen a serious and imminent threat to public health or public safety, to the life or health of a client or other individual. So the particular section there is Section 6, Principle 11F. Unauthorised disclosure can also be made for a purpose for which the information was obtained or directly related to such purpose under Principle 11A. Agencies delivering public services share information for at-risk children, so that's just an executive decision that's been made that information can be shared to assist vulnerable or at-risk children. So all those things sort of keep the school counsellors bound unless there is a real genuine risk, and it has to be a genuine and serious imminent risk of harm. Parents aren't automatically entitled to counselling records. So as I said, just because you're a guardian, it doesn't mean that you automatically can access any information about a child that's under your guardianship. Under Section 22C of the Health Act 1956, parents are able to access medical records of young children. So young, but however bearing in mind, tempered against the fact that when a child reaches the age of 16, they're fully in control of their health records. And we would probably argue that under the international law, because they're autonomous individuals and seen as having rights to their privacy and dignity under the United Nations Convention on the Rights of the Child, you should respect that right to privacy once they're old enough to come into being, make autonomous decisions, and make a decision about their privacy. Where abuse by a family member is suspected or where a child does not consent to disclose to a counsellor, a counsellor can refuse such a request on the grounds it would be an unwarranted disclosure of the affairs of another. So again, that's sort of protection, but obviously if there's imminent risk of a young person, the counsellor may be entitled to breach that confidentiality. The Privacy Commissioner has issued a practical guide to health information privacy, noting that a counsellor can explore the reasons for refusing disclosure and try and find a middle ground with a child and parents. Obviously, if you are genuinely worried that a child's going to be at risk, even if it's not imminent risk, but at risk, there may be grounds for trying to take that route if you're a school counsellor. So a bit more about privacy and parents generally. Under the Health Act, a young person's representative, parent or guardian may request access to health information. An agency may refuse to disclose this information if A, the disclosure would be contrary to the individual's health interests, B, the agency has reasonable grounds to believe the individual does not want the information disclosed, and C, there would be good grounds for withholding the information. So fulfilling those elements, if that is the case, they may be entitled to refuse that information. And, the argument being that really if we take a consistent interpretation of the law in line with international law, that young people are autonomous and have the right to their own privacy. So that kind of gives you a big overview, kind of the right to privacy in schools. It's sort of a really tricky area because obviously counsellors and school nurses and potentially teachers and school staff come into contact with students all the time and a lot of private information, and obviously parents would be concerned about this information, parents or guardians. So it is really difficult to sort of balance those. But, our top take-home tips really are that UNCROC has an important bearing of all aspects of this. So recognition of a young person as an autonomous individual that has a right to privacy. Overall, when you take into account the privacy code and professional codes of conduct, all information does need to be protected, and we'd say, erring on the side of caution, if in doubt, no disclosure unless there's express authorization or immediate risk of harm, so really needing to show that immediate risk in order to justify disclosure of that information. Hopefully that's given you a good overview of some of the aspects around privacy, and thank you very much for tuning into our webinar. I'm just going to leave the chat box open for a few minutes for anyone that's got any further questions. That concludes our webinar series for this year in education law. I trust that you found it helpful and useful, and we really look forward to your feedback through the SurveyMonkey chat box function. The slides will be available on our website, and also this will go up on YouTube, so that people that do want to watch it again can watch it. And yeah, feel free to give us an email or contact us on the website if you do have any further questions. So here's some information about how to get in contact with us. All there, and yeah, we have our app which we've developed, which is downloadable on smartphones as well. Please, we'd really appreciate if you're able to do the webinar survey. It really helps us to give reports on how we deal with webinars and whether people find them useful. And if there are a number of people on one computer, if you could all type in your names into the chat box, that would be wonderful as well. So yeah, I'll just leave it open for a couple more minutes, and then I'll close the chat box if there are no questions. But thank you very much.